Hello, everybody. Welcome to another Barnes Law video and podcast. Today we're going to talk about the Roger Stone trial and the many problems and questions that arise from the Roger Stone trial. The very first one is the fact that he was prosecuted at all. The nature of the charges against him basically surround his testimony before Congress and whether or not he attempted to interfere with another witness's testimony before Congress. What's impactful about it is that ultimately the statements that the government claims were material misrepresentations or perjury. They ultimately charged Roger with a combination of obstruction of justice, making false statements, and witness tampering. But the nature of those charges did not show that there was any material impact or effect on the actual investigation. What they accused Roger of lying about was claiming that he had connections that he did not in fact have. The witness tampering that they charged was the witness testified at trial that in fact he never felt impaired or interfered with or tampered with at all. He took it as simply the repartee that he had traditionally had with Roger Stone. So the first unusual aspect of the Roger Stone trial was that he was being prosecuted at all, given that there was no apparent impact on the government's ability to perform or do their job, number one. Number two, that the witness who they claim was tampered with and that justice was obstructed relating to said he was never in fact tampered with, nor did it in fact obstruct any justice in the case. Not only that, the nature of the allegations concerned testimony primarily and principally before Congress, not before a grand jury, not before a criminal investigation of some consequence, but simply before Congress. This is an area where people can often be accused of making misrepresentations about testimony before Congress and are almost never prosecuted. So the selective prosecution of Roger Stone was the first principal and primary problem of the Roger Stone trial. The second major problem with the Roger Stone trial was where they chose to prosecute him. This is called venue under the criminal laws, and under the law, venue can be any place where there's a connection to the crime. In this particular instance, they could have chosen to prosecute Roger Stone in Washington, D.C., but they also could have chosen to prosecute him in Florida or New York. What's notable is that gives a venue choice to the prosecution. To give you an example, in the Wesley Snipes case, where I defended Wesley Snipes, there are a bunch of other defendants who are accused of being co-conspirators. The government manipulated the venue selection process so that they tried Wesley Snipes in Ocala, Florida, before an all-white jury in an area that had the highest incidence of per capita racial hatred incidents at the time, while they tried his co-conspirators, almost all of whom were white and from the South, in Washington, D.C. This is the kind of abuse of venue selection that can give rise to a constitutional claim, not just a statutory claim. So the first problem was selective prosecution of bringing charges at all, given the factual circumstances and context of the case, and the fact that similar people, including John Brennan, who's been accused of lying, the former CIA director, he was never prosecuted. Clapper, the former head of national intelligence related to the NSA, who notoriously lied in such a way that Ed Snowden ended up becoming a whistleblower because of it. James Comey, who there's been allegations that he misled Congress. Andrew McCabe, allegations, of course, that he lied to almost everybody within the FBI about his own illicit leaking conduct against President Trump. None of these people are being criminally prosecuted, yet Roger Stone is being prosecuted in a case that had no material impact on anybody, that has no identifiable victim at all, and that the main witness says he was never tampered with and doesn't understand why Roger is being criminally prosecuted. So first problem, selective prosecution. Second problem, abuse of venue. They could have brought it in New York, where they would have got a much fairer jury pool potential, or Florida, where they would have got the fairest potential jury pool and where Roger Stone actually resided. But instead, they chose Washington, D.C. Washington, D.C. was the most anti-Trump area venue in the entire country. It has had a recent history of refusing to charge or convict people who committed crimes against Trump, while being eager to convict for people who are associated with Trump. This ended up being materially relevant and pertinent at the jury selection part of the process, which we'll get to a little bit later, that deals with the case. So, selective prosecution and even bringing the charges, problem one. Venue manipulation, problem two, but it doesn't stop there. Third, the prosecutors manipulate how they get the judge in the case. So a typical case will have there's supposed to be random assignment in the federal process to make sure that neither side can hand-pick the judge of their choice. You want random. In fact, that random assignment is considered a due process right because violation of it basically denies you the same process that everyone else is entitled to. But in this case, again, the prosecution manipulated that as well. The prosecution chose to claim the case was, quote, a related case so that they could handpick their judge, a judge who had shown a clear bias against anyone associated with Donald Trump. This was a judge who had ruled against Catholic, who was an Obama appointee, had tight ties to the Obama administration, whose family had ties to the Obama administration and Democratic politicians, who had ruled against people seeking relief in the Benghazi case against Hillary Clinton, who had ruled against Catholics and others seeking relief from mandatory issues related to contraceptions and abortion treatment. And so she had a clear pattern. But even after that, she had made extraordinary rulings in the Manafort case and the Gates case, cases she also somehow managed to obtain jurisdiction over, in which she was basically giving gag orders that deprived people of their basic ability to speak in their own defense, to raise money for their own defense, to be able to mount a defense, to be able to identify potential witnesses for the defense, to be able to defend themselves in the court of public opinion, which is often in political cases as important as the court of law and the court of the jury and the judges. She had actually effectively put Manafort in solitary prison in punishment before he was even sentenced or convicted of a crime. She had denied him access to bail. She had threatened other people associated with Trump of denying their access to bail. So the prosecution knew that she would be a very anti-Stone judge in all probability. So rather than allow the random assignment of judges, which could appoint a judge who did not have such a bias, they claimed the case was a related case to other cases when, in fact, the trial would show it was not related at all. Indeed, the government and the court would deny various discovery requests and various motions to dismiss on the very grounds that it was completely unrelated to those other cases it was purportedly related to in the first place. This was rigging the case in order to ensure a certain outcome. So the prosecution does it by selective prosecution and control of who prosecutes it. It comes out of the special counsel's office rather than referring it to an independent assistant United States attorney who may have had a different judgment about the case. Secondly, by manipulating the venue selection in the first place to have judges and juries likely to be hostile to Roger Stone rather than the actual venue where he is from and where he lives, which would have been a much more nonpartisan, non-prejudicial jury. And then third, manipulating the judge that was going to be appointed to the case by claiming it was a related case when it was not to any other pending criminal proceeding. But that would not be all. The government wouldn't leave any unconstitutional stone unturned in the prosecution and punishment of Roger Stone. So that's why the fourth thing they did was a range of discovery tools they used in discovery to deny him access to certain amounts of discovery, to conduct a raid on his house at the time of his arrest that would create this perception of him being a great dangerous threat to the world. So anybody following the news at all would have a prejudice against Roger Stone based on the way in which that raid was done. Not only the fact that the raid was done, which was extraordinarily rare. In a case like this, an older defendant, a nonviolent alleged crime, no serious material impact on the criminal case or any other case that had happened to date, you do not do a raid, period. You usually do a summons for them to appear in court. You only do a raid or any sort of perp walk, as they call it, when they arrest them and show them off for the cameras for PR purposes to prejudice the defendant and to make themselves look good. But here they went far past that. They not only did a perp walk, they did a 6 a.m. early morning raid And they not only did a 6 a.m. early morning raid, they did it with SWAT team personnel to make him look like he was Pablo Escobar. And they not only did that, they took it another step and made sure somehow magically it got leaked to CNN so they could live show it to their audience. An unheard of thing to happen. Think about all the famous cases you've ever heard of. Have you ever seen live the raid on their homes and their arrest? Never. Why? Because in fact it's dangerous and risky to do that. But also it's prejudicial to the defendant. It creates a perception of guilt before he can ever reach the jury, before he can ever reach the court of public opinion. So first you have selective prosecution, then you have venue manipulation, then you have abuse of the judicial assignment process, then you have an early morning raid that they leak with SWAT team personnel that basically convicted Roger Stone before he ever stepped foot in any court anywhere in the country. But that wasn't all. The fifth step they would do is they would manipulate how they handled discovery so that certain items that he wanted he would never get, certain exculpatory information, that's evidence that would prove your innocence, was never turned over or provided. Information related to the FISA abuse was not turned over. Information related to, and FISA, by the way, that's the Foreign Intelligence Surveillance Act, which allows for spying on spies. It was never supposed to be used. In fact, the statute was designed to prohibit and prevent the government from using it the way that Nixon had tried to use it, which was to spy on Americans, to spy on domestic activities, the way J. Edgar Hoover had used it in the COINTELPRO operations and the like, the way the CIA at times had used it, the way the NSA at times had used it. The famous Church Committee on Intelligence Activities, which was the first ever committee on intelligence, meant to supervise the intelligence community, not be the intelligence community's tool in Congress, which is what it has become, unfortunately, was by Senator Frank Church. And the reason why he was so curious about all these things back in the late 1970s, he was one of the first United States senators Americans ever spied on by the NSA. So this law, FISA law, was meant to prohibit and prevent any kind of misuse and abuse of the spying powers of our government on domestic Americans. And now we have tools and techniques for domestic spying that never even existed before. Now they do exist. And so what's happening is it's being misused and abused. It's being weaponized for political partisan purposes by the John Brennans of the world, by the shadow government operatives within the Obama administration who continued to have power even after Trump got elected because there was a failure to replace those people quickly and effectively and a naivete about what they were up to. The people who helped set up General Flynn. Well, a lot of that information involved government misconduct, malfeasance, misuse and abuse of the FISA provisions. FBI has now admitted that to the FISA court that issued the warrant, that they misled them and there was not a probable basis for those FISA warrants to even exist. Initially were done on Carter Page, which then led their ability to surveil everybody else. Whether or not that is what led in part to the investigation of Roger Stone was critical, but much of that information and evidence was never turned over to Roger Stone in his case. So a part of his whole defense he was never able to mount because he was denied the means to do so. So first you have selective prosecution. Second, you have manipulation of venue. Third, you have abuse of judicial assignment. Fourth, you have a lunatic televised raid. And fifth, you have discovery process that is not done in a constitutionally conforming manner. But that's not all. Then it comes to jury selection. In a case like this, where you know you have a jury pool whose opinions of an individual's guilt are going to be heavily shaped by their political perceptions of the world, it is a constitutional violation of their Sixth Amendment right to have a trial by jury, and that trial by jury includes an impartial jury, a jury that comes in with no prejudice at all that could impact or influence their case, or that they admit and validate and verify that they're able to put aside any such preconception or prejudice. To give you an example and an illustration of this, in the Wesley Snipes case, 3 jurors lied to get onto the jury, claimed that they were impartial, later admitted to the other jurors that they were not impartial, and they were the reason why there was any convictions at all in the case. Well, Snipes was acquitted of all felony charges, acquitted of all fraud charges, acquitted of all tax evasion charges, acquitted of all conspiracy charges, and acquitted of multiple misdemeanor charges. He was convicted of 3 minor misdemeanors only because 3 jurors refused to leave the jury room until there was a conviction on those counts, even though the other 9 jurors believed he was not guilty on all of those counts. So that's how jury bias can impact, influence, and plague a trial. Here, the jury pool was overwhelmingly Democratic, hated Trump. Less than 4% of the people in the District of Columbia voted for Trump. They had the most hostile opinions towards Trump were in D.C. And not only that, they had a recent history, both in grand juries and trial juries, of basically doing jury nullification, not allowing criminal prosecutions to move forward against people who are hostile to Trump, while being very anti-Trump in their approach to any grand jury or jury trial question. So it's the equivalent of having Martin Luther King tried in 1960s Birmingham to an all-white jury pool with close friends to the law enforcement apparatus and Bull Connor. That's what trying Roger Stone in Washington, D.C. on Trump-related charges is in the modern era. Given that, it was critical, essential, fundamental to do detailed jury selection. Now, unfortunately, a lot of lawyers don't do a lot of the kind of jury selection that needs to happen. They rely upon their instincts, and often their instincts are flawed. Most lawyers are part of the professional class now by definition, but often come from the professional class. They have very little life experience. That's why the Roger Stone trial is educational about many things beyond Roger Stone, beyond Donald Trump, beyond Russiagate. It goes to the core of how the criminal defense process works in America, how the justice process works in America, and what happens when a trial goes off the rails like this one did, because a judge would refuse to enforce constitutional rights for a defendant she simply did not like. And for a government that was prosecution that was willing to bend the rules or break the rules to achieve their desired objective. And a press that was complicit because of their partisan political preferences of the same kind. That's how, in fact, most people get railroaded. It's some combination of press complicity, jury complicity, judicial complicity, and prosecutorial complicity. Usually you need at least 3 of those 4 in order to achieve a miscarriage of justice, like what the Roger Stone case was. So what did they actually do in the jury selection process? They did not have sufficient follow-through questions, did not go into much detail. Apparently the jury forewoman herself lied. And why wasn't this exposed at the time? Well, that goes to one of the other extraordinary abuses of constitutional liberties that took place in the Roger Stone trial, and it's the gag order and the jury and anonymity order. So those 2 things work together. So first you have a selective prosecution, abuse of the venue, abuse of judicial assignment, a televised raid in the morning, a denial of basic discovery rights. But that wasn't all. The judge basically issued a gag order, and that gag order was plainly, flatly unconstitutional. You can read law review articles from 20 years ago by liberal professors like Cherminsky and others who have said almost every gag order is unconstitutional. That's because it is a prior restraint on your free speech, and those are presumed under Supreme Court law to be unconstitutional. You have to overcome an extraordinary burden as a court to prove that a gag order can ever be necessary. I probably litigated more gag orders in the country in recent memory than most lawyers in the entire country, maybe any other lawyer in the country. And anybody who investigates and reviews and researches the actual law will find that in order to prohibit someone from speaking, you can't just use the existence of a court case as an excuse to do so. You don't lose your constitutional rights because somebody either sues you or you sue somebody or somebody charges you with a crime. You don't suddenly lose your First Amendment rights. Probable cause of a crime found by a grand jury is grounds to arrest you and is grounds to require some bail to make sure you will appear at trial. That's it. It is not now you no longer have First Amendment rights. Now you no longer have Second Amendment rights. Now you no longer have Fourth Amendment rights. Wrong, 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 wrong. Those are called unconstitutional conditions. You can look it up. There's a famous Ninth Circuit case on it. And the point is you cannot use the fact that someone has been arrested as grounds to deny them or deprive them of their other constitutional rights or liberties. In fact, it is precisely in those circumstances that their constitutional rights and liberties must be secured, must be safeguarded, must be protected. So here in that context, what happens with Roger Stone? Well, the judge finds various pretexts to immediately issue a ridiculous gag order that was plainly and flatly unconstitutional, that prohibiting from speaking about certain people and participants related to the case. Now, what is the impact of that? We'll get to how it dramatically impacted what happened in jury selection, but it also impacted the whole process of the case. For example, by your ability to defend yourself in the court of public opinion, that is often critical in a political case, often more important than whatever happens in the court of law, because your personal future, your reputational future, your financial future is often contingent and dependent upon the ability to defend yourself in the court of public opinion. And often that financial future is connected to your ability to defend yourself in the court of law, to be able to afford the lawyers and the investigators and the paralegals and all the things that go into adequately, jury selection people, going into adequately, effectively defending yourself in such a high-profile political prosecution against the most powerful government in the world in a criminal case. So that's part one. Part two is the way a gag order impacts you, is that often your public discussion of the case will lead to independent investigators, grassroots investigators, finding things out that you didn't know that become helpful and critical for your case. Not only that, it often leads witnesses to come forward, witnesses to recant, witnesses to re-examine. So the entire process becomes one in which your ability to defend yourself in the court of law is contingent and dependent upon your ability to defend yourself in the court of public opinion, particularly in high-profile political cases. I've had several cases. I defended some controversial defendants in a range of cases, and I won't go into detail what happened in those specific cases, but I'll tell you the general thing that happened repeatedly. When we defended the client in the court of public opinion, witnesses came forward with critical new information that was exculpatory and essential to our client's defense. That happened repeatedly. Frankly, it's happened in almost every case I've ever defended in the court of public opinion. The job of the lawyer in defending a client in the court of public opinion is not to try to somehow prejudice the juror with inadmissible prejudicial evidence. The probability of that even occurring is remote to non-existent. By contrast, the actual objective is to not only keep them alive financially, professionally, reputationally, their personal lives intact while this horrible assault on them takes place, which is what a criminal prosecution is in the court of public opinion in high-profile political cases. But also it's essential to find there's some witness out there that knows something that you don't know, that the government doesn't know, or if the government does know, they've been trying to cover up and suppress. So I had a case in which a witness was a purported whistleblower against my client. Turned out they were actually a scam artist fraudster trying to get a bogus whistleblower claim who had created the entire predicate for the whistleblowing event to even occur. They were the ones, in fact, responsible. It was their wife and friends who outed them once they found out the information that we were able to talk about publicly. So it's critical and essential to defending someone like Roger Stone to be able to have full, unfettered access to the court of public opinion. So what did the judge do almost from the beginning of the case? Deny him his ability to communicate in the court of public opinion. She issued a gag order, and not only did she issue a gag order that was flatly unconstitutional, prohibiting him from speaking about the case, she ultimately prohibited him from speaking about almost anything even tangential to the case. He wasn't even allowed to talk about whether Robert Mueller was corrupt or not, because somehow that was connected to the case, even though Mueller was no longer on the case, which was ludicrous. The entire purpose of our criminal justice process and the First Amendment rights is to be able to talk about whether the judge is being corrupt or not, whether the prosecution is being corrupt or not, whether the government witnesses are being corrupt or not. This goes back to a great state, Gentile versus state of great case, Gentile versus state of Nevada, where the Nevada State Bar tried to prohibit a lawyer from defending his client in the court of public opinion. And what that lawyer did is that lawyer went out, called a press conference just a few months away from the trial, and accused the prosecution, the police, and other witnesses of being complicit in a conspiracy to commit perjury and frame his client. That's extraordinarily inflammatory kind of information. But he thought it essential to his client's defense. He thought it essential to get other witnesses to come forward. The state bar tried to punish the lawyer for doing that. The U.S. Supreme Court unanimously came back and said, no, you can't punish someone for their First Amendment rights, and you definitely can't punish a lawyer for protecting somebody else's First Amendment, Fourth Amendment, Fifth Amendment, Sixth Amendment, Eighth Amendment rights, which is what he was doing. So here you have a gag order that's unconstitutional in the first instance, prohibiting Roger Stone's ability to help really meaningfully raise funds for his defense, limiting the gag order allowed him to raise money for his defense, but limited what he could talk about in order to enable that to happen in the first place. Not only that, prohibited Roger Stone from being able to develop evidence and informational leads from the public, and ultimately hampered the ability of Roger Stone to be able to argue or to be able to expose potential jury misconduct. Because what happens when you have a gag order is you have a bunch of jurors who may have problematic histories in their past. They may be lying in the jury selection process because of their bias. The nature of a biased person is they don't admit their bias. So like asking a juror, hey, by the way, are you biased? The only one who's going to admit bias is the one whose bias is not going to impact their proceedings. It's not going to impact their trial because they're self-aware. The biased jurors are often not self-aware, and to the degree they are, the bias leads them to lie because they want to secure a certain outcome. And so here you had a bunch of Trump haters, and as it turned out, Roger Stone haters on the jury, who had already made up their minds before the case even began. But so here was a key for the government and the judge: how to cover that up, how to keep the world from knowing about that, how to stop Roger Stone from exposing that. Well, you gag Roger Stone, number one, and then number two, you require the jurors' names be anonymous. Anonymous juries are foreign to the whole history of a right to a jury trial going back 8 centuries. The whole point of a Magna Carta would have had no effect. How could you have a jury of your peers in the Magna Carta if you have no idea whether they're your peers or not? Right? It's a joke. Jury selection is meant, when you participate in a jury trial, you're participating in government. You're deciding somebody's future. You're deciding somebody's, in the criminal cases, their freedom, their liberty even to live in some cases. You are not entitled to anonymity. If you want to be anonymous, refuse to participate in jury selection, and you can see whether that's something you can do or not. It may not be legal depending on the circumstances of your situation. But either way, once you're part of the jury, you're now part of the government. That's a requirement of citizenship. And the duty, and that requires transparency as to who you are, whether you have a bias, because these trials the public has a right to a participation in the trial. Your right to a trial is not a right to a secret trial in Guantanamo, which is basically the equivalent of what they tried to do in Roger Stone's case. It's to have a public trial, and a public trial requires not only Roger Stone to be unfettered in his ability to participate in the court of public opinion, but it also requires us knowing who the heck is deciding the case. Are they biased? Are they prejudiced? We need transparency, and that's precisely what the judge denied Roger Stone and denied us, the community, denied us our ability to meaningfully participate and supervise our own government. So, in fact, and then ultimately, inevitably, inescapably, was consequential. Apparently, the person who ended up being the foreperson of the jury was apparently lied on her jury forms, failed to disclose material information throughout the process, misled the court and Roger Stone's defense as to the scope and scale of her potential areas of bias. And her bias was clearly quite strong. She had a whole Twitter feed and social media posts that made clear she had prejudged who Roger Stone and Donald Trump were, had made negative statements about Roger Stone prior to the trial, then claimed didn't really know who he was. It was a clear evidence of a prejudiced, bigoted juror in the case, or at least evidence that would require much more information than was disclosed during the jury selection process, which could only happen because the judge said that nobody can know who the jury is. Jury anonymity is a relatively recent phenomenon, completely foreign to our history. It was instituted in terrorism and mob cases in fear of retaliation against the individual jurors, and has always been controversial, and in my view is unconstitutional, period, in all cases. But at least in this case, there was simply no basis to do any form of jury anonymity, especially when you combined it with a gag order and a prejudicial jury pool in a selective prosecution that was politically motivated in a venue that was littered with problematic jurors and in which the judge was not randomly assigned but handpicked by the prosecution. But that wasn't all that happened in the case. After it became clear there was potential juror bias, some members of the press, including Alex Jones at InfoWars, said, hey, look, there's some problems here with some of the apparent people that are part of the jury process. We don't even know their names, but it looks like their biographical association connects with this, and this seems like a problem. What happened? Members of the press, members of the former prosecutors, people with connections to current prosecutors, and even comments apparently made by the court basically threatened Alex Jones for even talking about it. That's what's going on here. You have a case of a rigged trial where their whole goal is to make sure the world does not know it's a rigged trial. Rigged in the selective prosecution in the first place, rigged in the selection of the venue, rigged in the selection of the judge not being randomly assigned, rigged in the gag orders, rigged in the denials of discovery, rigged in the jury selection process, rigged in threats to the press or the public if they talk about it in any particular manner that they don't like. And then, of course, ultimately we have the prosecutors recommending a ludicrous sentence that was completely out of whack, 7 to 9 years. And the judge ultimately issuing a 3 to 4 year sentence, which is still completely disproportionate to what happens in cases like this. This is a case that involves a first-time offender, has no criminal record. Number 2, he's old, he's elderly. Number 3, there is no victim in the crime. The government wasn't actually victimized. There was nothing that Roger said or did not say that ultimately impacted or impaired their ability to investigate the case. The main witness who was supposedly tampered with said he wasn't tampered with. There was no victim here, really. And then fourth, you're talking about a case that under the sentencing guidelines, and to give you a brief background on what the sentencing guidelines are, in federal criminal prosecutions in the United States, there's a United States Sentencing Commission that recommends a range of sentences for certain kinds of offenses. The point and purpose of the Sentencing Commission primarily was supposed to be to make sure that we're not getting disparate outcomes, that we're not having due process violations by prosecuting one person in one town for the same thing one way, and then the same person, a different person but same charge, same basic facts, but just a different judge, and you get a totally different sentence. They wanted to limit that disparity, limit what appeared to be prejudice and preferences in the judicial sentencing process. Originally, the sentencing guidelines were made mandatory. That was always unconstitutional, but typical with the Supreme Court. It took them a decade and a half to finally tell everybody that it was. Once it was, judges are not bound by it. But if they follow it, it's very rare that their sentence will be overturned on appeal. Here, the sentencing guidelines would typically, and the sentencing guidelines have this number calculation, and the number calculation is based on what the charge is, and then based on whether certain enhancements apply, whether certain mitigating factors apply, what the person's criminal history category is, and then you go to a sentencing chart that has the number and the criminal history category of the defendant, and let's say it's number, your sentencing range is called, or your sentencing point is called 14, and your criminal history category 1. Then you go down there, and that will give a 6-month range of, let's say, 12 to 18 months, something like that. And it has that. It's a big, long chart. You can look it up yourself, sentencing table chart, and you can see what that is. The points on the left come from the Sentencing Commission's recommendations based on the facts related to the crime. The points on the top relate to the criminal history category, how much of a person has this person had a criminal history problem, and that creates the guidelines. The guidelines have proven to be mostly ineffective and inaccurate in how they sentence people. The reality is that people who commit certain violent crimes, certain crimes toward children, and other crimes are much more likely to have a recidivistic risk. People connected to gangs, people that are not citizens here, the risk of recidivism, the risk of flight is much higher than it is for if you have always been a citizen here, you have a tight-knit family, you have a tight-knit community, you're older, and you have no criminal history. That's the kind of person that typically, when there's no real victim in the crime, gets probation even upon conviction. Worst case scenario, something like what's called 12 months in a day. And what that does is, because good time credits kick in once you serve more than a year, you get 15% off. And so what happens is 12 months in a day ends up being like 10 months. Some part of that 10 months may be served in a halfway house. It's all served at a low level, what they call a federal work camp, which doesn't really require like that much work, but has almost no violence, very low risk. That would have been the norm for Roger Stone. As a whole, there's almost no examples of these kind of prosecutions ever being brought. I know of no case of witness tampering ever being brought where the witness said he wasn't tampered with. I know of no obstruction case being brought where they couldn't identify how the person's statement had any impact whatsoever on an actual criminal investigation. Cases concerning lying to Congress are almost never brought. If lying in Congress was a crime, none of our congressmen would still be there. They'd all be in prison. So, the idea of prosecuting this has always seemed a little peculiar to people observing it. Usually it requires some exceptional, extraordinary, or unusual fact pattern that was simply not present here. So there's almost no comparisons. And the few comparisons you can bring, people who've committed the same offense within the same criminal history category, same local ties, families, communities, etc., usually get 12 months in a day on the high side. And yet Roger Stone got 3 years. And 4 prosecutors resigned because they wanted 8 years. That's the insanity of this criminal prosecution. And for President Trump and Attorney General Barr simply commenting on it, they were threatened by various members of the political establishment, the press, former members that are prosecutors, other members that are currently prosecutors, of saying they will resign unless their punitive partisan prejudices are implemented fully. So that's the Roger Stone trial, one of the most abusive examples of a rigged trial in recent modern American history. manipulation of the prosecution in the first place. It was selective, politically motivated prosecution in violation of his First Amendment rights. Then manipulation of the venue choice in violation of his Fifth Amendment rights. Then a manipulation of the random assignment of judge to self-select a biased judge in violation of his due process rights under the Fifth Amendment. Then a raid, an unnecessary, unwarranted, unjustified raid, televised with SWAT team folks coming in, meant to intimidate and terrorize people like himself and other members who are associated or affiliated with President Trump. Fifth, denial of basic discovery rights that due process under the Brady line of cases requires, enforced through the Fifth Amendment of the U.S. Constitution. Then the gag order. Now, what's unique about the gag order is it managed to violate probably 4 or 5 different constitutional provisions. It violated his First Amendment right of free speech. It violated the right of the press to have access to him, another First Amendment right. So it violated the First Amendment in 2 separate, different, distinct ways of different groups of people for which he had standing to raise on both of their behalves, his behalf and theirs. Next, Fourth Amendment violation of an invasion of his right to privacy in certain respects, not only by the way the raid was conducted, being excessive and disproportionate and disparate, but by the scope and scale of the gag order and how it impacted his associational ties. His ability it was basically a threat to any family, friend, or ally that if they did anything, Roger might get blamed for it. So it limited the scope to which he could communicate and work and associate with whom he chose. A simple right of association, which is protected under the First Amendment, and in certain circumstances has a Fourth Amendment implication. Violation of his Fifth Amendment rights to due process of law in the entire proceeding about almost everything that happened, but also in the gag order, because similar gag orders are not issued in similar cases. A violation of his Sixth Amendment rights because it really interfered with his right to counsel. It limited the scope of being able to enforce his right to confrontation inside the courtroom by information he was not able to develop outside the courtroom. And the right to confrontation, while it's the right of confrontation under the Sixth Amendment is the right of cross-examination. It's the right to confront your accusers. That right is not meaningful if you're not able to develop the information that is essential to make that cross-examination or confrontation effective, which is what happens when you deny people discovery, when you deny people the right to argue in the court of public opinion that could produce and elicit essential information that's either exculpatory for you or incriminatory for your accuser. Violation of his Eighth Amendment rights in particular. The gag order's most offensive provisions were its First and Eighth Amendment provisions because the court decided to condition Roger Stone's bail, his right to bail, on denying him his right to speak. This is another unconstitutional conditions provision. There was a case in the Ninth Circuit some years ago where they tried to deny a person their Fourth Amendment rights against their property being searched, their privacy being invaded in exchange for them getting bail under the Eighth Amendment. Ninth Circuit said, no, that's unconstitutional, and all evidence developed that way must be suppressed. The same logic is true here. Bail is only the constitutional provision of bail guarantees you bail unless the court finds that you will not appear at trial unless it denies you bail. That's fundamentally what it is. Now, in the mid-1980s, the Supreme Court expanded that to say you can also deny someone bail if you have clear and convincing evidence that they are an imminent threat to the public. That's always been a very controversial decision. It was a 5-4 decision. Somewhere down the road, it may be reversed. It's a modern decision that's contrary to much of the constitutional history of bail. But putting that aside, Roger was never accused of that. So the only issue in Roger Stone's case was what bail was sufficient to secure his appearance at trial. There was no doubt he was going to appear at trial because he had known of the investigation for years. He had never fled at all. In fact, in general, the probability of a person fleeing in a federal criminal case is almost non-existent. And the requirement constitutionally is there has to be a showing by a preponderance of the evidence that unless they completely deny him bail, he will not appear. And unless they can meet that very high standard, they cannot deny him bail in a case. So here, there was no doubt that Roger Stone was not at risk of flight. So you cannot condition his right to bail on whether or not he exercises his First Amendment rights, his Fourth, Fifth, Sixth, and Seventh Amendment rights, or in this case, Fourth, his First Amendment right of free speech, his First Amendment right of free association, First Amendment right of access to the press and to be part of the press, his Fourth Amendment rights against invasions of his privacy, which can in certain contexts include the way and manner in which he speaks, his Fifth Amendment right to due process of law, his Sixth Amendment right to confront witnesses against him and a right to an impartial jury, and his Eighth Amendment rights to bail. You can't violate all of those rights as a condition of his bail. And yet that's precisely what the court did here. So you have these extraordinary violations of constitutional rights, a rigging of a trial from beginning to end, selective prosecution to selective punishment, with a jury selected that was nowhere near the impartial standard of the Constitution of the United States. That's what happened in the Roger Stone case. It's why, hopefully, President Trump will pardon him. President Trump should pardon him simply because of how abusive this criminal proceeding was, and a reminder that such proceedings should never be utilized again in our country. There are other independent and separate grounds to do so, including the whole bogus nature of the Mueller inquiry and the Russiagate conspiracy theory, popular in certain elite press circles. We'll see what happens. Hopefully justice will come about. Thank you for joining us today.